Let me do. My lord, I may be allowed to move an urgent petition, my lord, eviction matter. So, my lord, what happened that notification 11/11/2022 asked for apply landless person. We applied and acknowledgement has been issued, my lord. But thereafter, my lord, without disposing that application, acknowledged application, my lord, they are going to evict us by eviction notice, my lord. So that is, there is urgency. Today or by tomorrow, they may evict us, my lord.
Tomorrow.
Tomorrow. My lord, at 2, my lord.
Huh?
At 2 today, my lord.
Not today, tomorrow.
My lord, tomorrow we may be evicted, my lord, in that case.
Have you filed it?
Yes, filed yesterday, my lord. Yesterday
filed
we have
yesterday?
filed, my lord. Because, my lord, it so happened that authority tomorrow evicted us, then will be problems.
No, let it be tomorrow.
Applies.
There is some.
Similar prayer, Lordship.
Yeah.
We are going to be evicted, Lordship, by tomorrow or day after tomorrow.
Tomorrow.
Applies.
Yes.
No, withdrawing, man.
Withdrawal.
We got the relief, man.
All right. Tomorrow.
Tomorrow.
Okay, please, Your Lordship, I beg to mention item 26. The conducting council is out of station.
20?
26.
Please, item number 12, my lord.
Wait.
Mention.
2026?
Yes, with the consent of the other party.
My lord, I am for the petitioners. Let it be on next Tuesday, my lord, on 27.
27th. It has to be in February.
My lord.
3rd February?
My lord.
All right, 3rd.
Of like,
Maybe item number 17, my lord. 12, my lord.
17.
12.
Ah.
It is a matter relating to rejection of my prayer in Basundara scheme, my lord. We are supposed to file affidavit in reply. The person is indisposed, my lord. So can I have a 1 week time to file the reply, my lord?
Item 12. After a week.
There is an interim order, I may be allowed to continue.
Interim order passed earlier will continue. 26th. Subpiece number 2. 3 तारीख है.
We have to lordship. Lordship, I beg to election item number 8, your lordship.
8.
Lordship. Also, there's some accommodations required, your lordship.
Also the
My lord, this is a long pending case, my lord. So it may come upon 3rd of,
3rd. Right, item 8 on 3rd.
my lord, no further adjournment.
Lordship.
On 3rd. Yes.
May I please? Lordship, this is regarding, mention is regarding illegal transfer posting. So I'll pray for early listing tomorrow.
Illegal transfer means then you'll have to mention before bench 3. This is not taking up service matters now.
May I please, your lordship, sir? It is an eviction matter, will carry it tomorrow, my lord.
Tomorrow, all right.
Same prayer, my lord.
Huh?
I have also filed 2 writ petition, my lord.
Same prayer.
Yes, same prayer, my lord.
Tomorrow.
My lord.
May I beg your lordship? I beg to mention item number 29, my lord. Mr. B. Rahman is out of station for his treatment, my lord.
Oh. Then
Item 29, my lord.
item 29 on a request made on behalf of Mr. B. Raman, stands deferred. Listed after 3 weeks.
My lord. Interim order may be continued, my lord.
Interim order passed earlier will continue.
Obliged.
Your lordship, in item number 2, we have filed an application, but we were informed by the local council that it is not as per the format of the Guwahati High Court. Lordship may permit us, give us some time, a week's time, and we'll file the application in proper format.
How much time do you?
Lordship may give us 2 weeks time.
2 weeks time.
Please, your lordship.
Item 2 on the request made on behalf of the applicant stands deferred.
Highly obliged, your lordship.
Mr. M. Sharma for the respondent. Thank you.
May I please, your lordship? I beg to mention item number 5 and 25, your lordship. Mr. Kyal has some medical emergency, your lordship. The matter may be adjourned for the week, your lordship.
5 and 25.
Yes, your lordship.
Oh, 5 and 25 stands deferred. It is listed after.
Next week on any date, your lordship.
Interim order.
On 5th.
Yes, your lordship.
5th of February.
Interim order that may be continued, lordship.
5th of February, on the request made on behalf of Mr. SCKL. Mr.
PK Bora.
PK Bora.
Bora.
Bora appears on behalf of the petitioner. Interim orders passed earlier will continue.
Obliged.
List again on 5th. of
Wait, please, your lordship. I beg to mention item number 24 of today's daily list for adjournment. The advocate concerned for the respondent is severely ill and unwell. So the matter may kindly be adjourned for today.
I am for the
24
Concern has been taken.
stands deferred on the request of Mr.
S. D. Gupta on behalf of S. Das Gupta.
S. D. Gupta, appearing for respondents 1 to 4.
Yes, your lordship.
I am for the petitioner, my lord.
Mr. B. Borua appears for respondent number 4.
Interim order.
For the writ petitioner, interim orders passed early. Will continue. List again after 2 weeks.
My lord, both have concern on 10th of February, my lord.
10th of February.
Yes.
All right, 10th of February.
Obliged.
Obliged.
Means of listing of a matter, demolition matter, notice issued by the GMs.
Tomorrow.
Can it be tomorrow?
May I please, your lordship? Lordship, I'd like to mention one interlocutory application related to WTC number 4258 of 2035. It was a eviction matter, lordship.
You want the IA to be listed.
Yes.
You file
Yes.
the IA.
Yes, lordship.
All right. When do you want it?
Friday.
Friday, all right. But Friday is a holiday.
Thursday.
Let it be on 28th.
Actually, lordship, the petitioner is facing difficulties because his address is wrongly mentioned in the writ petition. So kindly.
All right, 22nd.
Please.
May please, your lordship. My lord, there was an IA for implementing, my lord. Pursuant to the order of the, in a writ petition, my lord, I filed the IA, my lord. So may I pray this IA may be come along with my writ petitions, my lord. Because the petition was fixed tomorrow, my lord, but not yet, my lord, listed, my lord. So I'm only praying.
You make a mention tomorrow.
Yes, yes, my
If
lord.
the writ petition is fixed tomorrow,
Yes, my lord.
you make a mention tomorrow, we'll pass orders. All right.
Please, your lordship, I beg to make a mention for listing of 2 matters for motion on Thursday, your lordship, day after tomorrow. There is an urgency in the matter.
All right.
May please, your lordship. Lordship, I would like to mention for listing of admission matters also next week. Any
It's 4th of February.
what of your
Yeah, please, your lordship. Lordship, for item number 28, sir, we have received the affidavit in opposition yesterday. I beg your lordship may grant us some time to file affidavit in opposition.
28.
Reply.
28.
Item number 28,
Item number
supplementary
28.
list, your lordship.
Item 28 on a request made on behalf of Mr. P. Mohanto. Matter stands deferred for 2 weeks. Enabling them to file reply affidavit. The affidavit in opposition filed by the respondents. List after 2 weeks.
Lordship, may kindly fix a date, your lordship. In the month of February, your lordship.
18th February.
Lordship.
18th.
Lordship, may I pray for an early date, your
Early
lordship,
date,
on the
your
4th or 5th, your lordship.
What is your lordship?
I'd already given 2 weeks. You
Okay.
take a date after 2 weeks.
Lordship, we'll have a consultation with you. Lordship, we'll decide on the date if we can inform the group.
18th.
80, much obliged.
Yes.
My senior is unwell today, my lord. So nothing will be done for things.
Matter stands passed over for the day on the request made on behalf of the writ petition. MS.
Senior is here, your lordship.
Mr. P. N. Goswami, additional AG appears for the state. They're seeking a passover for the day,
Maybe a short date, Mal, because I have given an undertaking that they will not be evicted. On that basis, they are continuing. Entire forest has been, well, evicted. But they are the 3 persons residing inside the forest.
28th
28, man.
28th of January.
Right to your lordship. Where in this case, lordship, the respondent number 2 had lordship filed an
a claim petition before the MECT tribunal, Lordship. And in that, Lordship, the petitioner was arraigned as, he deposed as deponent number 2, Lordship. Deponent number 4, Lordship. Then thereafter, the Honorable Tribunal has granted, Lordship, the compensation amount of, Lordship, 1 lakh something to the petitioner therein, Lordship. But, Lordship, at page, para 23, Lordship, of the judgment, Lordship, it page 29. A direction was given that the petitioner as a lordship defendant witness number 4 had given false lordship evidence before the honorable tribunal, lordship. Though it was in the WS and everything, it was stated that he never deposed any false evidence, lordship, but it was directed that it was held that he deposed some false evidence before the honorable tribunal. Therefore, lordship, the honorable tribunal has directed the Vasishta police station, lordship, to register a case against the lordship, the petitioner here in lordship. But lordship, as per the lordship, section 340, the honorable tribunal has no power to direct the authority, direct the police station to register a case in case of lordship, if it is the false evidence given before a court, lordship, not before a tribunal also. Lordship may come to section 340 of the criminal procedure. Criminal procedure code. Here, please. Section 340 is to be read with section 195, lordship. I'll come to 195 later on, lordship. Section 340. May I read that? Procedure in cases mentioned in section 195. Okay. When upon an application made to it in this behalf or otherwise, any court is of opinion that it is expedient in the interest of justice that an inquiry should be made into any offences referred to in clause B of subsection 1 of section 195, which appears to have been committed in or in relation to proceeding in that court, or as the case may be in respect of documents produced or given in evidence in a proceeding in a court, such court may, after such preliminary inquiry, if any, as it thinks fit necessary, record a finding to that effect, B, make a complaint thereof in writing, and C, send it to a magistrate of the first class having jurisdiction. So, lordship, the procedure is that it should be an internal committee, the court should come to a finding that he has made a false statement has been made, evidence has been done, then it should be sent to the magistrate of first class. There is no provision to send for registration of a case before the police station. Lordship may come to section 195 of the CRPC. (195) 1 clause B, sub clause B. (195) says, lordship, no court shall take cognizance, lordship. Then B, clause B1, no court shall take cognizance of any offence punishable under any of the following sections of the Indian Penal Code, namely section 193 to 196, that is giving false evidence before the proceeding, 199, 200, 205 to 211. When such offence is alleged to have been committed in or in any relation to any proceeding, any court, or of any offence described in section 463 or punishable under section so and so. Then lordship, below Yes, it is given, Lordship, that except on the complaint in writing of the court, there should be a complaint by the court in writing and that to be forwarded to the Lordship magistrate, sent to a magistrate of first class service jurisdiction, Lordship. Lordship, this procedure, which is mandatory, Lordship, has not been followed here. And moreover, Lordship, the petitioner has never deposed falsely. He was there in the, Lordship, he was riding the bike actually.
Anyone for the respondents?
I am for the performer respondent, respondent number 5.
Hmm.
But in fact, my father lost the FIR. And in fact, the petitioner was, my lord, riding the bike, my lord, I was pillion. The, my lord, respondent number 5 was pillion riding. And in fact, my lord, the award, my lord, has already been certified. My lord, the
No, it's
claimant
not
has
that-
already got.
Ah,
The claimant has already got the award, my lord. In fact,
there's no dispute on that.
yes, my lord.
Dispute is with regard to the direction of the
Direction.
registrar.
With otherwise, my lord, it is a fact that he was riding the bike, my lord. Petitioner was riding the bike. I was sitting pillion, my lord. That is, there is, I fail to understand, my lord, where.
Where is that false statement?
No, Lordship, may come to the paragraph, page 20 to paragraph 12. This is the petitioner's statement before the Honorable Tribunal, Lordship. Paragraph 12.
Hmm.
May I read, Lordship? The opposite party number 3 has examined one Sri Santosh Kumar Poddar as DW4. He is the petitioner hearing. According to him, on 23/12/2014, he went for a ride by a motorcycle bearing number so and so from the residence of Dilip Kumar Roy at Dwarakanagar through Khanapara to Beltala Tiniali. The son of the owner of the vehicle was also traveling with him as a pillion rider of the motorcycle, and he is by name Prince Roy. Here the response number 5, Lordship. As soon as they arrived at the near Gaurikota Sok, the claimant proceeding from a subway towards main road by riding a scooty and then dashed against the motorcycle driven by him. Accordingly, he controlled the vehicle in standing position without falling on ground. However, some people started gathering at the place and on being apprehended, he left the place, leaving the motorcycle thereon with Sri Prince Roy, who accompanied him as a pillion rider. According to him, neither the motorcycle nor the scooty driven by the claimant was getting damaged. The claimant herself also did not sustain any injury. However, he has got valid driving license. However, the owner of the vehicle, Dilip Roy, informed him subsequently that Oriental Insurance Company has inquired the matter from him. Accordingly, he also submitted an application on 17/5/16 before the manager of the Oriental Insurance Company Limited. Details relating to the occurrence that took place on 23/12/2014. Accordingly, he has submitted the driving license copy of the so and so. So, Lordship, here the petitioner was riding the vehicle, Lordship, and the respondent number 5, who was a minor, he was behind, he was the pillion rider. But after committing the accident, the petitioner fled away from the side because the mob was there who was trying to hit him, Lordship. So manhandled him. So he left the place. Then police, Lordship, submitted that the minor, the Lordship, son that the respondent number 5 was riding the Lordship. Therefore, the Honorable Court Tribunal has held that he made a misleading statement that he was not riding the Lordship, the vehicle, Lordship. Otherwise, also the law to be followed, mandated by the Lordship, the Act, Lordship, that has not been followed here, Lordship. And the claimant has already got the relief also. And claimant has never made such any complaint before the tribunal also.
Has the FIR been registered now?
No, Lordship, there is stay order. Operating.
Who's for respondent 4?
It will be the government, my lord.
And Lordship, a case was also registered before the Juvenile Justice Board, Lordship.
Hmm?
Before the Juvenile Justice Board, wherein after hearing the statement of the Lordship respondent number 5, that he was the pillion rider, the court has acquitted him, Lordship. So there is that the petitioner herein he was the rider, Lordship. He was riding the vehicle. But Honorable Tribunal has Lordship held Lordship that he was not present at the site. So he technically misled the court. Cross. Lordship may come to the cross part of the respondent petitioner, Lordship, at page 22. Is page 23, Lordship. Cross of the Lordship petitioner and DW4. Put to cross examination, he has stated that he could not recollect the color of the vehicle. He left the place only after the accident was over because of the fear that the mob will manhandle him. He does not know as to the quantum of injury that sustained by the injured because he had no time to see but to save his skin. He has admitted that the owner of the vehicle, Dilip Roy, is his friend. He did not take care about Prince Roy at the time of occurrence and thereafter left the place of occurrence, allowing Prince Roy to be manhandled by the mob. He has been to the police station on the next day, but no written representation has been given to the police. He does not know whether the police has investigated the case and find material against the driver Prince Roy, and also does not know whether the case has been charge sheeted against the said Prince Roy. However, he denied the suggestion that he has deposed falsely only to save skin of the owner of the vehicle from liability of the case, so moto taking the plea that he is the real owner and not the Prince Roy. Actually, even if it is admitted that the Prince Roy, that the respondent number 4 was riding, 5 was riding the vehicle, then also, Lordship, the procedure has to be followed as mandated by the Lordship statute.
Whether it was a correct statement, incorrect statement
Yes,
is one aspect.
yes. But the
According to
procedure is another aspect.
procedure prescribed under 340
Yes.
has not been followed.
Yes, that is not.
Is there anything to submit?
Actually, I'm
Who are you representing?
respondent number 6, Oriental Insurance.
Hmm?
I think, Your Lordship, the procedure should have been followed. Preliminary
Are
inquiry.
you relying on any authorities?
It is, Lordship, that tribunal cannot, Lordship, give, tribunal itself cannot give, Lordship. Only the court can, Lordship, give a written complaint for that only. But one recent judgment is there, Lordship. Has not been reported. Is number 6. That is the time person.
Okay, anything more? We pass orders disposed.
Obliged.
I said, no, I think I was.
Offline কৰিছিলা বোলে? Offline কৰিছিলা নেকি?
Yes,
Lordship, I have received once. Go apply কৰিবলৈ কৈছে। সেইটো reject কৰিছে। Offline কৰিছিলা?
NOC.
you have to submit online,
Lordship.
only online, then
Only online.
you submitted online application for NOC,
My lord.
which had a time limit, expired.
My lord.
You submitted for extension offline. They say you have to submit online. That's it.
This is now. You can apply at any time, Lordship.
So we close it on this ground.
Lordship, look.
Third council for parties.
Ajay applied to the.
The limited grievance with the writ petitioner is that he had applied for NOC or a sale of a plot of land. Stop the NOC was obtained from the office of the district commissioner for Beta on 23/6/24. Stop. However, because of computer system failure in the office of the deputy registrar, the sale deed would not be registered. The NOC, which was earlier issued with the writ petitioner, also expired on 24/12/2024. Subsequently, when the petitioner attempted to have the sale deed registered, the same was declined by the deputy registrar on the ground that the NOC had expired. The application made by the petitioner before the office of the additional district commissioner for Beta seeking extension of the NOC was also not accepted. Stop. Under such circumstances, the petitioner has approached this court. Upon being liberty granted, the learned standing council, revenue and disaster management was permitted to obtain instructions. Stop. Today, when the matter is called up, Mr. J. Hendick, learned standing council representing
I am for the state, Lordship.
for the state, for the deputy commissioner for Beta has placed before the courts a set of instructions and has submitted that the NOC granted to the writ petitioner was on an application made by the petitioner through the online mode. Stop. However, upon expiry of the period of the NOC, period specified in the NOC, the extension was or application for extension was made in the offline mode. Stop. Under such circumstances, an NOC which was granted on the basis of an online application can be extended only when the application is made online. Stop. Come on. Considering the instructions received by the standing council, by the government council preparing for the state, and the submissions made before this on the basis of the instructions received. This court is of the view that the writ petition can be closed at the stage, granting liberty to take steps to apply for extension of the NOC by for a fresh NOC.
But they all have to apply for fresh NOC.
Apply for a fresh NOC online. And if such an application is made, then the respondent authorities will issue such an NOC without any further delay. With the above observation, the writ petition stands disposed of. How much time do you require for issuance of an NOC?
15 days. And let some process. They have to verify that
Once an
documentation.
online application is made by the petitioner, then the NOC shall be issued within a period of 15 days on the date of receipt of such. Yes, sir.
So this is the case where the 148 notice has been challenged,
Which notice?
148 of the Income Tax Act. For the year 2012-13, you'll also kindly see the list of dates below.
Yes.
So for the assessment year 2012-13, the petitioner company submitted the return of income online on 17/9/2012, along with the computation of total income and the report of the auditor containing the profit and loss account, balance sheet, and for the said assessment year. Now, Babylon Trading Company Investment Company submitted its return income online along with the balance sheet and audit report. Now, this is the company who invested as shares in the petitioner company. So the petitioner was served with a notice under so-and-so issued by the so-and-so in the property excise powers under section 136 of the Income Tax Act, following upon information with respect to the transaction with one so-and-so limited for the financial year 2012-13 relevant to the assessment year 12-13. In reply to the said notice dated so-and-so, the petitioner submitted a reply and furnished all requisite papers and documents required by the department of so-and-so in respect of the transaction made with so-and-so for the financial year 11 relevant to the assessment year 12-13. In spite of the submission of the papers and documents by the petitioner company in compliance to the notice dated so-and-so, the petitioner was surprised to receive a notice issued by respondent form in the purport excise powers under section 148 of the Income Tax Act for the assessment year 2012-13, proposing to reassess the petitioner company for the assessment year 12-13 on the ground that there was reason to believe that the income of the petitioner for the assessment year 12-13 had escaped assessment within the meaning of section 147 of the Income Tax Act, and directing the petitioner to deliver return in the prescribed manner within 30 days from the date of the service of notice. In the said notice, it was mentioned that the said notice was issued after obtaining a sanction from the Principal Commissioner of Income so and so. Thereafter, petitioner submitted the return. Thereafter, on 26/4/2019, the petitioner requested the authority for the regions for reopening of the assessment order and the regions for issuance of notice under section 148 of the Act. On 6/5/2019, no regions recorded were however furnished to the petitioner, and instead a notice so and so by the respondent so and so was issued to the petitioner in the purported exercise of powers under section 143(2) of the Income Tax Act to produce books of accounts and documents in support of the return submitted by the petitioner for the assessment year 2012-13. So thereafter, the petitioner again made a request that the regions were not furnished by letter dated 10/5/2019. Now, 26/5/2019, the regions were not communicated to the petitioner, and instead a notice dated so and so by the respondent for under section 142(1) of the Income Tax Act was issued to the petitioner, directing the petitioner to furnish the accounts and documents in connection with the regions for the assessment for the assessment year. The petitioner again, my lord, on 14/10/2019, requested that the regions of the reopening of the assessment be forwarded. Thereafter, my lord, on 21/10/2019, the respondent for thereafter, by letter day, so is communicated to the petitioner the regions for reopening of the assessment recorded on 29/3/2019 within the meaning of section 147 of the Income Tax Act 1961. Thereafter, a penalty notice was issued under section 271(1)(b) on 5/11/2019. Then, my lord, on 8/11/2019, the petitioner submitted his objections to the regions recorded in reopening of the assessment for the assessment year 12-13. And then again, petitioner submitted reply considering the submissions of the petitioner, the respondent for by letter so and so dropped the proceeding under section 271(1)(b) of the Act. Penalty proceedings were dropped. Respondent for by letter so and so gave reply to the aforesaid objections filed by the petitioner in respect of the regions recorded in the opening of the completed assessment. Thereafter, again, my lord, 274 and with 271(1)(b) notice was issued, and then again 71 notice was issued. Now, you'll also may kindly see the return of income petitioner submitted at page 48.
Yes.
And my lord, the petitioner received a sum of rupees 30 lakhs, my lord, from the said Babycon, my lord, limited on account of the shares the detail of the shares you'll also find at page 61.
Yes.
Then, my lord, at page 70, you'll also may see you're at the bottom. You also find 20 lakhs
Mm.
was received from the said company. And the next page again, my lord, fourth item from the bottom, my lord,
Mm.
said company 10 lakhs was received.
Yes.
Thereafter, lordship may notice was issued and your lordship may kindly see case 74. The account of ledger account of the so-and-so baby corn trading investment limited in the petitioner's books of account, 20 lakhs and 10 lakhs, the 30 lakhs.
Yes.
The 148 notice, you'll also find it page 78. Now the reasons recorded
Where are the reasons?
at page 86, Miller. May I read, Miller?
Yes.
Trans India Limited and SSC under circle number so-and-so,
Just 1 minute.
Milo.
Hey, if I enter. Who's on not trying to say. Enter. You know, we will have with the whole. Yes. ma'am.
Milo. At page 86, Miller. Dissemination of information received from the Deputy Director of the Income Tax Unit so-and-so in the case of Trans India Developers Limited in relation to the inquiry in the case of Rebellion Trading so-and-so, Babylon so-and-so, PAN number so-and-so, assessed with ITO so-and-so Calcutta. On examination of the bank number so-and-so in the name of Babylon Investment Limited, it is observed that the bank account is credited with the transfer of RTGS which were directly credited to the beneficiary concerns or layered through the bank account of sale companies and finally transferred to the bank account of the beneficiary concerned. The intermediary companies as mentioned in the database of the sale paper companies have provided accommodation entries to the form of bogus share capital, share premium, LNP, and bogus LTGS, secured loan, etc. to various beneficiaries paper entries. Number so-and-so Trans India Developers Limited in lieu of commission in cash and controlled and managed entry operations. It is found on analysis that the unaccounted income reached to the desired destination through banking channel in this process. This is common practice of Jama Kharch companies in Kolkata. These are operator driver transactions which resulted into entry received from the beneficiary companies in the bank. For opening entry in the bank book, beneficiary provides cash to the operator which is deposited in the individual or dummy proprietor's accounts allowed by transfer of the accounts of the different concern. On further verification of the transaction, it is found that Messrs. Brahmaputra so-and-so, Bar Limited, SSC company, is the beneficiary having transactions of rupees 25 lakhs made in the financial year 2012-13. It has no connection with the petitioner. The whatever he's mentioning, that has no connection because he's saying about some Brahmaputra something. We are not connected and 25 lakhs. From the above, it is a case that during the previous financial year and aforesaid, the concerns have brought unaccounted money in the books and money laundering channels, the source of fund credited to the books through layers as to into the light of the provisions of section 68 of the Income Tax Act 1961. Now, in this case, the case of the petitioner, the amount has come directly from the Baby Corn Limited. There were no layers. It has not come through some, the layers company, sale companies. That is not so. As per the latest SOP dated so-and-so of the Income Tax Act, it is found to assessment on so-and-so after obtaining prior approval of the CIT. Guwahati, reply was received from the SSC claiming that the amount was on account of the share capital of the SSC subscribed by the Messrs. So-and-so. Nothing was furnished to establish the genuineness of the transaction or the creditworthiness or the actual existence of the Baby Corn so-and-so limited from the furnished ledger party, it is noted that the total value of the transaction rupees was rupees 30 lakhs. I have reason to believe. He is saying, my lord, that the petitioner has not produced anything to show about the genuineness of the transaction, the establishment of the company, and the creditworthiness of the said, my lord, baby corn so and so. Now, we'll also kindly see at page 102. No, my lord, I'm sorry. For the slip. Page 90, my lord.
Hmm.
So and so about the existence of the company. These are the details from the company, my lord. This is portal, my lord, about the said company. And also may see at the last company status for affiliating active. This is about the company about which they are saying, my lord.
These were furnished before the
Yes,
assessing of.
yes, yes. Because that was the regions recorded, and thereafter, my lord, all the documents were given, and even then he has rejected it. Now we'll also see page 102.
Yes.
This is the, my lord, the computation of the income of the petitioner, my lord. And I will take it also to show that in the books of account of the said company, baby corn mill so and so, he has shown the said amount as being invested in the petitioner company. You'll also see page 121. Bottom from, my lord, 8 to 10 items, my lord.
Yes.
Trans India Developers Private Limited, 30 lakhs. As you also got it, my lord.
Yes.
This is the, in the books of accounts of the said company, my lord.
Hmm.
Now, in the books of, in the bank account of the said company, my lord,
Yes.
they are see also reflected is 20 lakhs and, my lord, 10 lakhs that is reflected in respect of the bank account of the said company.
Yes.
Now, if you also look into the regions which have been given are only 3, my lord. That one, the existence of the company itself. Second, the creditworthiness. And third is the genuineness of the transaction. Now, once the petitioner has shown that the company is a registered company, which is submitting its income tax returns also and has disclosed the said income in the income tax returns, the question of saying, Milord, that the company is not in existence does not arise. Now, secondly, Milord, the creditworthiness of the person giving the amount once in the books of account of the said company, the person concerned has disclosed that where from the said amount has come and it was given to the banking transactions to the petitioner. It cannot be said that the said company doesn't have the creditworthiness to give the amount. So far as the genuineness of the transaction is concerned, since the amount was given through the banking transactions and directly from the said company to the petitioner, it is not a case, Milord, that which they are saying that it has come through layers. That is not correct, because the amount has come to the petitioner directly from the said company. Now, the allegation is that, although not in so many words, that the said company received from some amount from some other companies, shell companies, and that amount was deposited in the account of the said company, and the said company gave the amount to the petitioner. Now, Milord, the petitioner, so far as whenever a loan is taken from some company, Milord, the petitioner can only take all precautions to see.
This amount is in respect of purchase of shares,
My lord, shared by the said company.
of shares of the petitioner company.
My lord. Now, my lord,
So he must have issued the share
yes,
certificates or something.
yes,
So those were produced before the,
the shares are with him. The shares which are issued remains in the position of the said company.
no, some corresponding material must be available.
Well, the materials which are there, if there are any dispute that whether shares are issued or not, we can give the amount, details. Whether shares were
Those
issued
were
or not.
never asked for.
They have not asked for, they have simply gone for the different issue at all. They have gone in the question that you have not proved the genuineness of the transaction and the creditworthiness of the said party. Now, once the person is an income,
The actual existence.
my lord, once the said company is an income tax assessee and is also assessed under the Income Tax Act, then to say that the person is not a genuine person and his existence and genuineness is in doubt, when the said person, my lord, in his returns, he has shown the said amount having been invested, and not one. So many companies he has invested the shares in the shares. If your lordship looks into the, my lord, the reply of the petitioner,
Page 88.
Annexure 13, my lord.
Yes.
At page 97,
97.
my lord.
Ninety-seven is annexure
I'm sorry,
16.
my lord, something. In
Annexure 13 is 91.
my lord. This is the, my lord.
This is a reply to the objection.
This is the order, my lord.
Huh?
It's okay, reply.
You're referring to the reply of the petitioner.
Page 88, my lord.
88.
So it says in para two, in first sentence is regarding receipt of the information from so and so on the account of the inquiry conducted in the case of so and so. What is relevance of the other observation para two could not be understood by us as regard the sale and paper companies, intermediary companies, Jama Khan company, etc. Because we have directly received the share application money from the Babycon so and so limited, and such fact was intimated and was in your knowledge when the owner conducted the inquiries under section 136 of the Income Tax Act 1961 on so and so, as mentioned in para 4 of the regions recorded. And nothing has been recorded in the regions that the so and so company is a sale company, Jama company, etc. And in fact, a regular company having filing status under ROC as active enclosed. Thus, there is a remains no reasons to initiate necessary proceedings. What has happened to inquiry is mentioned in whether the company itself has accepted to be bogus entry or they have denied having made investment in our company. Nothing has been mentioned in the regions recorded. Further, simply on the basis of the inquiries of some other person, our case cannot be reopened that when we have discharged the same, disclosed the same in the return of income. In this connection, we rely on the decision of the Delhi High Court rendered in the case of so-and-so versus so-and-so in WPC so-and-so. The apex court held rejected the SLP of the department on so-and-so. We'll also may skip over and we'll come to next page. On reading this statement, it is clear that it is clear that the information was not meant for us, but for someone else who are having transactions of rupees 25 lakhs. We have transactions of rupees 30 lakhs with the state company, for which reply was made when the assessing officer communicated to us on 133 under section 133 of Income Tax Act. As regards para 2, we have to state there is no involvement of the various financial years. Further, it is objected that the reassessment proceeding cannot be initiated for making robbing inquiries, as has been presumed by your honor by observing in para 3, the source of fund credited in the books routed through layers to be looked into in the light of the provisions of the Income Tax Act, because it has been judicially held that assessing officer belief should be on escapement of income in as much as the direct amount has been received from the so-and-so limited, and there is no question of routed through layers as has been presumed in the proceeding so-and-so. Well, he has said that this amount was routed through various layers, which is not the case of the petitioner at all. As regards para 4, we are to state that in the reply to the notice number so-and-so, we are not supposed to establish genuineness of transaction as otherwise conditions imposed under section 68 of the Income Tax Act as has been presumed by your honor. The information called for was replied properly, in which we have replied having transactions of 30 lakhs and furnished, apart from the papers, ITR 5 PAN card of Mr. So-and-so as desired by you of the said company below. As regard para 6, we would like to information that how the said have been recorded in the regions recorded, because your signature is after recording para 6, whereas firstly regions recorded should be sent to the learned CIT, and such as such, please let us know whether any other regions recorded were sent to the CIT for approval, and it is sent and the same were sent, and when the approval was granted, the copy of the regions given to us BS date at 29/3/2019 and notice under section 148 also have been confusion may kindly be shared. That, sir, we would that the word income has been defined in the section 214 or 24 of the for the purpose of 147 escapement of income. The same definition applies, which does not include any addition to be made under section 68 or 68D of the Act. The addition, if any, to be made in under these sections under the head simply for aggregation in the bench outside. So, below the 3 conditions under section 68, which are there, my lord.
Yes.
The genuineness, the credit worthiness, and the existence. Now, existence has been proved. The genuineness of the transaction has been proved. that it was to the banking transactions and it was disclosed by the said company in the income tax returns itself. And also the creditworthiness, because the amount is mentioned in the balance sheet and all of the documents, the credit net of the person concerned cannot be doubted. The basis, my lord, he is saying that the Jama Kharchi company and all these companies, such type of companies operating in Kolkata, so that is a general statement. Such type of companies are operating in Kolkata does not mean that every company which is receiving the amount on account share capital is a Jama Kharch company. The reasons recorded have no rational connection, my lord, with the escapement of income and is totally a perverse finding having no connection whatsoever. And they are saying, my lord, that no, the creditworthiness, the genuineness and existence has not been proved. My lord, on the facts of the case, it cannot be said by any stretch of imagination, my lord, that the creditness, the genuineness and the, my lord, the existence of the company has not been proved. And if the same have been proved, it cannot be said, my lord, that the said transaction was not genuine. Only on the basis that in Calcutta, certain companies are paper companies, sale companies, and, my lord, the Jama Kharchi companies. That is known everywhere. But that doesn't mean that every company will be a sale company. Even my company is a sale company. My company is, my lord, they engaged in the construction business, building business. And all the returns, etc., have been, my lord, furnished. Tax has been paid. If it was a sale company, if it was a paper company, why you have collected the income tax from me? Why my return was accepted? There cannot be any income at all. There cannot be any construction business at all. It will be only paper company.
Yes.
Yes, I'm a business in case now. Okay, so they told me.
Any counter file?
Lordship, we have filed our affidavit and we have also filed an additional affidavit, Lordship. And they have also filed their, my lord, reply affidavit to the affidavit.
Right. Yes.
Page 10, my lord. This was also a case of under section 68 of the Income Tax Act 1961. You'll also kindly see at page 15.
Yes.
The second paragraph, look. On the basis of the cases cited above, it is to be seen whether in the present case the SSC could discharge the onus regarding the receipt of the case credit. The tribunal in its judgment indicated that the identity of the creditor was not enough. It is true that by proving the identity of the SSC cannot be said to have been discharged its honors. In the instant case, the amounts were shown in the income tax returns of the SSC. Besides, the creditor has also shown the returns about giving of the loan to the SSC. Strangely, the income tax officer, while making the assessment in respect of the three creditors among them, accepted the returns. This itself will go to show that the amount received by the SSC was at least prima facie genuine. As the ITO accepted the returns of the three creditors, it should go to mean that the amounts given by those creditors were also genuine. On going to the tribunal judgment, we find that the tribunal observed, of course, the confirmation letters were filed in the instant case. The ITO went further and verified the assessment records of the creditor, from which he found various facts as mentioned in the assessment order and discussed by us in above. Thus, in our opinion, identity of the creditor above is not sufficient. It has also to be shown that the creditor had the capacity to advance the loan and the loan was genuine. The tribunal, however, did not make any endeavor to give any cogent reasons why the income tax returns filed by the creditors and accepted by the ITO should be ignored. In our view, the SSC had at least proved the case accordingly showing so.
Yes.
Now we'll also kindly see page 1. Six. Page 6, my lord. The division bench of this on the court.
Page 6.
6.
Yes.
Para 17.
Hmm.
Person may have funds from any source, and an SSC on such information received may take loan from such a person. It is not the business of the SSC to find out whether the source of sources from which the credit has been agreed to advance the amounts were genuine or not. If a creditor has by any undisclosed sources a particular amount of money in the bank, there is no limitation under the law on the part of the SSC to obtain such amount of money or part thereof from the creditors by way of check in the form of loan. And in such a case, if the creditor fails to satisfy as to how he had actually received the said money and had happened to keep the amount in the bank, the said amount cannot be treated as income of the SSC from undisclosed sources. In other words, the genuineness as well as the creditworthiness of the creditor has to be adjudged vis-a-vis the transaction which he had with the SSC. The reason why we formed the opinion it is that the business of the SSC is not the business of the SSC to find out the actual source of sources from where the creditor has accumulated the amount which he advances as loan to the SSC. So far as the SSC is concerned, he has to prove the genuineness of the transaction and the creditworthiness of the creditor vis-a-vis the transaction which had taken place from the SSC and the creditor, and not between the creditor and the sub-creditor, or it is not even required under the law for the SSC to try to find out as to what amount of sources from where the creditor has received the amount to his special knowledge under Section 106 of the Evidence Act. Now, my lord, I am posing a question to myself, my lord. I take a loan from someone. He gives a loan by check to me. If I ask the person concerned that you tell me where from you get the amount, now the person concerned, whether he is going to disclose to me that where from he got the money.
Yes.
If that is expected of an SSC before taking a loan, then it will be impossible. A bank gives me loan. A fraud who has created a person fraud, a smuggler, he deposits the amount in the bank. Now the bank gives me the amount to me. Can it be said that since the smuggler or the fraud was created the amount, the person has deposited the amount in the bank, so the loan which was given to me, that is also not genuine?
What is their stand in the affidavit?
The stand is that again the same whatever they have repeated.
In the reasons?
Reasons.
Now, Mr. Setia.
Lordship.
Come to page 121.
My lord.
Lord.
121, Dr. Saraf will just come back. We just want to ask him.
My lord,
We just want to ask him a query.
my lord.
Now, this 121 is a document by the company which has made the transaction,
Lord.
right? So there, the petitioner happens to be one of the companies. There are other companies also.
Lord.
Have you proceeded against all of them?
Lordship, the department has proceeded against many companies, my lord. We have filed an additional affidavit, Lordship. We have given the annexures, my lord. Lordship, what was happened, my lord, that Babylon company, my lord, they existed only on papers, my lord. They have invested in various companies, my lord. And my lord, in return, they received cash, my lord. So this information, my lord, that was received from the, my lord, after a detailed investigation was conducted by the, my lord, the departmental, my lord, proceeding, lordship. And in fact, my lord, the directors of that company, Babylon company, they have accepted that they are the directors existed only on papers, my lord. We have everything, we have brought it on record, my lord, by way of an additional affidavit, lordship. So, my lord, the question is, when, my lord, in a particular transaction, one company is established to be, my lord, a shell company, my lord, they involve in a bogus transactions, whether, my lord, the other company, my lord, which they have received, so far as receipt is concerned, my lord, that is not disputed, my lord. Whether that suffered to taxation or not, that is the question, my lord. And in fact, my lord, with this information, lordship, my humble submission, my lord, it is a fit case for issuance of notice under section 148, my lord. All conditions were satisfied.
Where is the report of the investigations?
Lordship, in our additional affidavit, your lordship will find it running page 155.
Yes.
That is our additional affidavit, lordship. May I read, my lord?
Is the report enclosed here?
Lordship.
Is the report enclosed? The
Lord-
director investigations?
Lordship, my lord, the details of the, my lord, the questionnaires, my lord, that was asked, my lord, to the directors of that particular company, my lord, Babylon company. That was enclosed, my lord. Your lordship may see the annexure A to our additional affidavit, my lord, internal page 9, lord.
Yes.
Details of inquiries made. The matter has been investigated. It is seen that name of Babylon Trading and Investment Private Limited appears in the department database of shell entity, which is controlled by entry operators Gopal Banka and Manohar Lal Nagaria. Amit Kumar Chaudhary, who was one of the dummy director of this company, has admitted in his statement recorded under section 131 of the Income Tax Act, so and so, that he had acted as only dummy director for the company controlled by Sri Manohar Lal Nagalia and used for facilitating accommodation entries to beneficiary companies. He had submitted a list of such companies during his statement wherein the name of Babylon Trading so and so appears. Further, it is seen from the inside pages of information provided by the reporting entity that bank account number so and so is in the name of Mrs. Babylon Trading, which is maintained at Kolkata main branch of Ecobank. Notice under section 131 of the Income Tax Act was issued to the bank and relevant bank statement were received. The same were examined and analyzed. On examination of bank account, it is observed that bank account is credited with transfer of RTGS, which were directly credited to the account of beneficiary concerns or layered through the bank accounts of shell paper companies and finally transferred to the bank accounts of the beneficiary concerned. So, my lord, both way, it is directly transferred to some companies and it is through some, also through other companies. The intermediary companies are mentioned in the database shell paper companies held with the department. Intermediary companies mentioned in the accounts are so and so, these companies are mentioned. No? These companies are shell paper companies which have provided accommodation entries in the form of bogus share capital, share premium, pre-arranged bogus LTGS, STCL, and unsecured loans, etc. to various beneficiaries parties in lieu of accommodation in cash and control and manage entry operators. The details of beneficiaries are given as below. Therefore, my lord,
Where is the name of the petitioner here?
my lord, at internal page number 14, serial number 133. So those are part of record, Lordship. So in fact, my lord, in their return, my lord, your lordship may see page 61, which was referred to, my lord. Notes on account from being part of balance sheet. Share capital, my lord. So, my lord, the amount which were transferred to this, my lord, petitioner company from the Vemil England, that was 30 lakhs. No, that was not mentioned on account of, my lord, purchase of share capital, my lord. It was 17 lakhs, equity shares of rupees 10 each, then 18 lakhs, and issued, subscribe and paid up capital. So and so, so and so. Thereafter, my lord, shareholder holding 5% or more of the aggregate shares. That is Arun Kumar Bajaj, Pavan Kumar Agarwal, Ratanlal Bajaj, and Rita Agarwal. So, my lord, the name of the, my lord, the Babylon is not reflected, my lord. So, my lord, question is whether that amount, my lord, 30 lakhs, that was actually on account of purchase of share or not, my lord. So, my lord, this is a fit case, my lord. We want to examine, my lord. Notices were issued, my lord, and my lord, they have not cooperated, they have not submitted their, my lord, these share certificates. Your lordship may see the annexed 13 at page, lordship,
Share
91.
certificates will be available with that company only.
So they have to produce, my lord. They have to have the records. We want to verify this.
You get
So-
it from the other company.
My lord, the investigation has been already proceeded against that company, my lord. And from there, my lord, statements, my lord, this information was forwarded to the assessing officer. And thereafter, my lord, notices were issued, my lord. It's only a notice, my lord.
No, that only a notice you'll have to
Lordship,
Have
I'll
to
satisfy,
pass the-
lordship.
eye test.
Lordship, in fact, my lord, it constitutes a sufficient, my lord, material, my lord.
What about the sanction of the CIT?
Yes, that has been obtained, lord.
Prior to
Issuance of the
submission
notice.
the reasons?
Yes, lord. Prior to issuance of the notice, sanction has been, my lord, granted, lordship. We have communicated to them.
Where,
That was not under challenge, lord.
where it has been communicated? It will not be communicated.
Lordship may see page 91, that is annexure 13, my lord. Relevant portion, page 92, last para. Regarding your query as to the date of approval by the PCIT Guwahati to Guwahati in terms of section 151 of the Act, the reasons recorded under section 142 of the Act on 29/3/19 was sent to the principal CIT Guwahati on 29/3/19 and the same was approved by PCIT Guwahati on 29/3/19 as the notice under section 140 of the Act would have got barred by limitation of time on 31/3/19. Hope this clears your confusion as expressed in brass so and so of your objection. So, lordship, the order itself, my lord, that clarifies, my lord, the sanction has already been granted. The only issue, my lord, the material, my lord, that is sufficient to constitute the reason to believe or not, my lord. That is the sole question. And in fact, my lord, Supreme Court says, my lord, at the stage of notice, my lord, 141, there must be some material, my lord. Sufficiency of the material, my lord, need not to be examined, my lord, at the stage of, my lord, notice, lord. They can satisfy the authority, my lord, by filing the
All right.
reply.
We'll have to examine this matter. We'll continue. What happened to there are judgments passed by this bench with regard to 148.
148, you also passed the order,
Oh,
but that was a case where the also said that after section was amended,
oh.
there is no responsibility.
Opus.
But that is not applicable because that was the case of, you know, whether he has disclosed all material facts necessary for the purposes. And that is also now pending in the appeal. You'll also kindly see one judgment, which my learned friend is saying that a director has disclosed the Supreme Court judgment at page 26.
Yes.
Page 29 million. Para 4.
Yes.
In his report, the income tax officer does not set out the reasons for coming to a conclusion that this is a fit case for basis of issuance of section 148. The materials that he has before him for issuing notice under section 148 is not mentioned in the report. In his report, he vaguely refers to certain communications referred to him from the CIT Bihar, and Odisha. It does not mention the facts explained, contained in this communication. All that he says is that from these communications, it appears that these persons, alleged creditors, are name lenders and the transactions were bogus. He has not even come to a prima facie conclusion that the transactions to which he referred to are not genuine transactions. He appears to have only a vague feeling that there may be a bogus transaction. Such a conclusion does not fulfill the requirements of Section 151(2). What the provision requires is that he must give reasons for issuing notice under Section 148. In other words, he must have some prima facie grounds before him for taking action under Section 148. Further, his report mentions, hence, paper investigation regarding this loan is necessary. In other words, his conclusion is that there is a case for investigating to be the truth of the alleged transaction. This is not the same thing as saying there are reasons to issue notice under Section 148. Before issuing notice under Section 148, the investigating officer must either have reason to believe that the reason of omission or failure on the part of the SEC to make a return under Section 139 for the assessment year in the income tax officer is reason or to declare fully and achieve all necessary for the purpose of assessment for that year, income chargeable tax has escaped assessment for that year, or alternatively, notwithstanding that he has been no omission or failure on the part of the SEC, the income tax officer has inconsequent information in his position to believe that the income chargeable tax has escaped assessment for an assessment year. Unless the requirements of clause A and B of Section 147 are satisfied, the income tax officer has no jurisdiction to issue a notice in the Section 148.
This is again prior to amendment.
Look, the amendment, prior to amendment also, Milord, you'll also find. After the amendment, the things have not changed. Only the years have changed, that 4 years.
He has to have some reason.
The reasons. Now the reasons which the Apex Court is saying that US, now my friend is saying that they are investigating in the case of the Babycon. They may be investigating. The Apex Court says that this is not the reasons to be recorded. That it may result in the something bogus and all those things. You must come to a finding that this is bogus. Where they have come to a finding in my case that I have not proved the creditworthiness, the existence and genuineness of the transaction. If that person is a shell company, the income will be added to him. If the amount has been received by him and he fails to prove the existence, creditworthiness and genuineness of the transaction, the income will be added to him. How that income can be added to me? If they are making an investigation against the third company, can it be said, Milord, that I have not proved the creditworthiness, genuineness and the existence of the company? My learned friend is saying that simply it is a notice. They will examine. 148 notice cannot be issued for making investigations.
That's true.
148 notice, one must come to a conclusion. Otherwise, Milord, in every case, one will issue the 148 notice and will say we will again investigate. That is not permissible.
Correct. There we are with you.
So my learned friend himself is saying that simply this is a notice. He will have a chance to explain why.
This is not an ordinary case of issuance of a show cause.
This is not a scrutiny assessment under 143.
All right, we'll continue. Again. On third.
Well,
Lot.
otherwise, Milord, every assessment at the whims of the income tax office, every assessment will be opened.
Heard Dr. Ashok Saraf here, advocate assisted by Mr. N.N. Bhatta and Mr. S. Setia, and a senior standing counsel.
Lot.
Income Tax Department. The arguments for the parties have remained inconclusive for further hearing on 3rd of February. Matter to be treated as parted. Third.
Public.
Item 7.
That was the decay. Against 3 whoever.
May it please, Your Lordship. A recovery or the passed by an estate officer under the Public Premises Act while holding his proceeding at Kolkata in respect of his public premises situated here at Panbojar is under essay here.
Yes.
Before I go into the ground of challenge, may I just very briefly indicate the facts of this? Our father, my lord, executed a lease agreement with LIC in respect of some spaces in a premises situated at Panbojar owned by the LIC. Then my father also executed an agreement, a franchisee agreement with JD Fashion Technology. And under that agreement, we was given the license to use the logo of JD Fashion Technology. And he initiated some undergraduate and postgraduate program on that rented premises. Subsequently, my father expired, and these petitioners are the only legal heirs. Now, this LIC, my lord, they initiated a recovery proceeding.
Recovery of?
Recovery of area of rent and damages at Kolkata. Initially, notice was issued.
Where is the property situated here?
Panbojar. That is the only question, whether it has the jurisdiction. Now, initially notice issued in our address at Panbojar. It was returned back as we already vacated the premises and shift to the new location, man. Subsequently, the officials of the LIC local office, man, they visited our office at Kilpukhari and handed over this notice issued by the estate office. Initially, we refused on the ground that it was addressed to Managing Director, JD Fashion Technology. Now, JD Fashion Technology is the franchisor. Nothing to do with that. We are the franchisee. So it was only in the name of MD JD Fashion Technology. But they forced to, my lord, accept it. We accept it. And then, my lord, we send Wakalatnama through post. And we also, my lord, from time to time file adjournment application, since it was a COVID time at the time. Subsequently, this proceeding was set ex parte. And the final order came on 25th of January 2022. That order was communicated to us on our personal name. So we instituted the proceeding challenging that order.
Where is that order?
It's page 20. Annexure 2.
Yes.
We are not on the merit, man. We are on the jurisdictional aspect only. That whether under the scheme of the Public Premises Act, whether the state officer can pass an order holding his proceeding at Kolkata, where the public premises is situated at Guwahati. In fact, that question is no longer res integra. Already been answered by the Supreme Court. Holding that it must hold these proceedings within the jurisdiction where this public premises is situated, where a cause of action arises.
Yes.
That's the law. So admittedly, His premises is situated at Guwahati. And our contention is it should hold his proceedings or trial at Guwahati, not at Kolkata. So this impugn order is only without jurisdiction. That is our challenge, madam, only challenge.
Yes.
Now they have filed their affidavit.
Mhm.
In their affidavit, they raised a preliminary objection
Hmm.
regarding our locus. Kindly take up their affidavit. Their case is that this petitioners not a party to this proceeding. This order was not passed against us. It was passed against MD JD Institute of Fashion Technology. And therefore, we don't have any locus. Para 2, running page 38. That is their stand regarding locus.
So first, let us take us through the order,
Yes, yes,
impugn order.
yes. Impugn order starts from page 20. It's an ex parte order. Direction us to pay 12,61,518. Lordship will find it page 34. Area rent is calculated at 3,04,824 and damages 9,56,394. And the sum total is 12,61,518. Page 34.
Do you have a copy of the lease deed?
No,
Not have a
no,
copy.
no.
Hmm.
Our case is very simple. Our father executed this lease deed.
No, the order apparently shows that it is against JD.
Right.
JD Fashion.
Yes, yes, yes.
But you are not JD Fashion.
No, we are not JD. It cannot be JD. JD is the franchisor.
Hmm.
We are the franchisee. It should be on our personal name. It is on form. I'm on substance. Because even they admitted, can you take up their affidavit? It's a contradictory stand. In one hand, they are saying that we lack locus. In other hand, can you see what they're saying? Can you see para 5 of their affidavit? Page 5.
Hmm.
Can you take up their affidavit?
Yes.
Para 5. Page 5. In reply to statement in para 7 and 8, it is stated that the state officer sent the notices in the address of the JD Institute of Fashion Technology as recorded in the lease agreement. Later on, the new location of JD Institute of Fashion Technology was collected, and both the letters dated so-and-so and so-and-so were sent to the new address. JD Institute of Fashion Technology, so-and-so, Nabagra Road, Guwahati, so-and-so, which were, however, not accepted and returned back with the comment refused. Reason being, my lord, it was addressed to JD Fashion Institute. Now, it is stated that the petitioners cannot save themselves of their duties and responsibilities by taking advantage of the corporate veil. That is their stand. Also see para 10. At page 9.
Yes.
May I read that the deponent denies the correctness of the statements made in para 17 and 18 and further begs to state that in spite of receipt of repeated notices of the estate officer, the petitioners deliberately avoided the proceeding initiated against JD Institute of Fashion Technology in case number so and so. And as such, it is legally not permissible for them to raise such plea in the instant writ petition, which has been filed under Article 226 of the Constitution. It is their own case. The repeated notices were issued to us, even on our personal name. Can you see? Can you take our reply? Affidavit in reply.
Yes.
Page 60. Last page, my lord. That is the final order communicated to us in our personal name. It is their own case.
Is there anything in the order which says that this order, although directed against the franchisor, is
No,
fully effective?
they proceeded on the wrong premise altogether. In a franchisee, my lord, suit, the franchisee should be named personally. Here, inadvertently or otherwise, they proceeded against a franchisor. JD
And
Fashion.
this franchisor was never appeared before the authority.
No notices were sent. Notices repeatedly sent to us. In our personal name. Also, MD JD Fashion Technology. Because this is their own case and para 10. That despite receipt of repeated notice of the estate officer, we failed to appear.
Now this JD, is it a party here?
No. But if my learned friend gives an undertaking that LIC will not proceed against us to execute this order very well and good, we'll be delighted. But it all bona fides, we are saying that lease deed is executed by my father, by our father. He expired. So we
So where
stepped
is
into
the
the
lease?
shoes of our father.
Where is the lease deed?
Admittedly, there is a lease deed. No dispute on that. My father executed it. He only described him as MD JD Institute of Fashion Technology. No dispute on that count. That's a purely hypotechnical one. I'm on substance. Let them say that they will not execute this order against these petitioners because they are not a party. Well and good, man. We'll be delighted.
Yes.
And my lord, how they can challenge the order itself?
Huh?
If they are not proceeded, then what is the meaning of the writ petition? How they can challenge the order itself?
No, they're challenging under apprehension. If you say that you don't want to proceed,
No,
we'll
once a
record
lease
and close it.
agreement is between the parties. Once a lease agreement between the parties, then party should come and say that is the order is bad.
That's right. According to you, they are not parties.
They have not made implemented JD also a party.
According to you, are they parties?
No, they are
No,
not parties.
They are
in
not
this.
parties.
They are not parties in this.
If they're not parties.
Yes, that meant writ
Can
petition is not
can the order passed by the estate officer be implemented against them?
Against, we have to prosecute, we are prosecuting against JD and we have to prosecute and execute against the JD. How they have, why they have come there?
All right, then we record and close it, that this order will be effective only with regard to.
Because the party, except the JD, because the order is against the JD enterprise.
Very good. And they are not JD.
They are not JD. Where they have
We
stated there
record
is
it
JD,
and
JD.
close it.
That is there, because the repetition is meaningless repetition. We'll execute against the JD.
Very well. That's it.
No problem. No problem.
Heard counsel for parties.
But
Yeah.
one, my humble submission is
Uh-huh.
that there should not be any bar to prosecute against the JD. And there is no, because-
JD is not even before us.
yes, that is why. That is there because my lord, my
We are
prayer is-
closing it.
my humble
What is-
my humble submission is that
Hmm.
there may not be any order that we should not proceed against them. In
Against?
the process, if it's JD, implementation, the process of the JD,
Hmm.
if they comes in the process, then only they should come. There is no such pleadings that proceeding has been initiated against them. So my humble submission before your lordship may not close this aspect. Because in the process of implementation of the JD, if they comes in process,
Who comes into the process?
they may be any higher. I don't know where's the now legacy of the JD taking that
You can't make, you can't blow hot and cold. I think you
Man.
say that this order
against JD.
is against JD.
JD.
And they are not JD. So
We have
therefore
not
this
proceeded,
order-
we have not proceeded against them. And we have not proceeded in
That's right. So
future.
that is what we want to record and close it.
My lord, what will be the in future? If the
Right.
process is
In the
JD come.
future, what happens, we don't know.
No, my lord, there is no such proceedings against them.
That is all
That,
we are
that
going
we,
to record.
that
and
cannot
close it.
we cannot be with our right to proceed against JD, and in the process their legal hire comes in the process, then that right will be extinguished.
We are not deciding a suit here.
Our right will be extinguished by this repetition.
Counsel for the parties, this writ petition is directed against the order dated 25/1,
2022.
25/1/2022, passed by the office of the State Officer, Public Premises, within bracket Eviction of Unauthorized Occupants Act 1971. The petitioner before this court. Petitioners submit that during the lifetime of their late father, late so-and-so, an lease agreement was executed by and between their late father and the LICI in respect of a property which is located in Panbazar in the district of Kamrup, Assam. Stop. Subsequently, these premises were vacated by the lessee. And however, according to the LICI, since certain outstanding amounts were due, the proceedings under the Public Premises PP Act was initiated by the state officer. The counsel for the petitioner submits that perusal of the impugned order reflects clearly that the proceedings are initiated on behalf of LICI, having its office in Kolkata, against one Messrs. JD Institute of Fashion Technology, who are the opposite parties therein. Stop. The impugned order was passed ex parte, and the state officer returned a finding that recovery of arrears of rent along with interest from the opposite party under section 7 within bracket 2 and 7 within bracket 2 capital A of the PP Act 1971 be proceeded with, along with an order for recovery of damages from the opposite party under section 7(2) of the PP Act of 1971. So a total amount of 12,61,518
12,61,528.
518.
518 is the amount which is calculated by the estate officer as recoverable from the writ petitioner who was named from the opposite party named therein. Stop. The counsel for the petitioner submits that the petitioner's late father executed the lease deed, but in the name of JD Fashion Technology,
JD Institute of Fashion Technology.
JD Institute of Fashion Technology, the execution, the lease deed was executed in whose name?
Page, Malad,
His
page
father
21.
released it.
Page 21, para 1, 2, 3, 4, 5, 6. That the indenture lease was executed on or about 2nd day of July 2007 between Life Insurance Company India Medsa JD Institute of Fashion Technology. In respect of
Was executed by LICI and Messrs JD Institute of Fashion Technology in respect of the said premises. Particulars of which are found in the impugned order. Stop. However, it is the claim of the petitioners that they do not represent Messrs JD Institute of Fashion Technology. And at no point in time had they represented before the LICI that they are the authorized representatives of the opposite party, namely Messrs JD Institute of Fashion Technology. Stop. However, notwithstanding that, the impugned order dated so and so was served on the writ petitioners in spite of their objections that they are not the proper party on which the impugned order was required to be served on. Stop. Apprehending that the amount reflected in the schedule to the order of rupees 12,61,518 being sought to be recovered from the petitioners, the present writ petition has been filed. Pursuant to notice being issued, the opposite parties had appeared and had filed their counter affidavit. Stop. The opposite, the respondents, sorry, opposite party respondents have raised a preliminary objection that the writ petitioners have no locus to challenge the impugned order dated so and so passed by the estate officer. The reason being that the order of the estate officer is directed against the opposite party mentioned in the impugned order, namely Messrs JD Institute of Fashion Technology. And the present writ petition is not preferred by the said opposite party. Stop. On this limited issue, upon a pointed query made by the court to the Standing Council LICI, the council representing the LICI reiterated his submissions as reflected in the affidavit that their claim in respect of the order passed by the state officer by the order dated so and so is only in respect of the opposite party named therein, namely Messrs JD Institute of Fashion Technology. Stop. Better, under such circumstances, if the respondents under such circumstances, when the respondents have made it clear by filing their specific affidavits, as well as in their submissions before the court, that the claim reflected in the impugned order dated so and so, amounting to a total of rupees 12,61,518, is directed against the opposite party named therein, Messrs JD Institute of Fashion Technology. And as a consequence thereof, the writ petitioners do not have any locus comma. This court is of the view that the grievance, the apprehension of the writ petitioners expressed in the present writ petitioners stand answered in view of the specific stand reflected by the respondents, that their claim for recovery in terms of the impugned order dated so and so passed by the state officer under the PPE Act is directed only against the opposite party, Messrs JD Institute of Fashion Technology. With the above observation, the writ petition stands closed, disposed of, recording the submissions reflected in by the respondents.
Correct. May I kindly record my challenge regarding jurisdiction and keep that question open, because eventually they will come.
The counsel for the petitioner has also raised the issue of jurisdiction of the
State officer.
State officer under the PPE Act, proceed and pass. The moment you question the jurisdiction, you are accepting that you are aggrieved.
No, otherwise, my lord, they will come again. Definitely they will come again.
Then
We have to raise this question.
The point. We'll make it clear.
Then
Why
if
you
we
are
come again.
necessarily inviting trouble for yourself?
Yes, yes.
This question we have not answered. You are entitled to raise it in subsequent proceedings if required.
Not
And recorded that submission. my lord.
The question of jurisdiction raised by the
Kept over.
petitioner has not been answered by this court in view of the order passed in the preceding paragraphs.
Yes.
All these questions will be available to be raised by the petitioner at an appropriate proceedings if the need so arises.
Yes, yes, ma'am.
Disposed.
Much. Much. Listen.
I'm petitioner in the item number 10, my lord. And my friend is item number 9 is the petition.
Object to your lordship's convenience. My lord, this matter will take some time if it is possible for your lordship to fix the matter on 18th of February.
18th.
18th.
My lord is also not well today, I have seen.
I'm quite well.
Okay.
Don't worry about that. But thank you for your concern.
I'm just observing.
As agreed to by the counsel for the parties, let these two matters be listed. 18th is a miscellaneous day.
Or then 19th?
Matter be listed for admission hearing. Is it admission hearing or hearing?
Admission hearing.
Admission hearing. On 19th of February. 19 February.
Yes, 19th. 14 also, item number 14 also, I'll seek a recommendations. My friend, it clears. On 18 or 19 any days subject.
19, we'll have it on.
Yes, yes.
Item 14, also on 19th, on the request made on behalf of Mr. B.D. Kaur, Senior Counsel. Mr. D. Gogoi for
Correspondence.
Forest, Mr. Odigari for
6, 7, 7, 8 and 9.
7. Right.
Yes.
Be honest.
This matter may kindly be taken up after some time. Mr. K. Gogoi is appearing for respondent number 1 and 2.
I would get that.
He's in Lakes, my lord, in before court number 1, my lord.
Yes, Dr. Saraf. After some time.
Yes, after some time. Obliged, my lord.
After some time. Or on some other date if you want.
Please convenient.
When was the other matter? When are the other matters fixed?
Third, you also have fixed up one matter.
Third. Then we'll keep it on 5th. 5th February.
Obliged.
On a request made on behalf of Mr. K. Gogoi. Matter stands deferred. Learner CGC stands deferred to be listed on 5th. Dr. Ashok Saraf, listed by Mr. P.K. Bora. Appears for the writ petitioner, Mr. P.C. Chutia, additional senior government advocate, appears for the respondent. State.
Okay.
Please, Lordship, by filing this writ petition, the petitioner has challenged the impugn order that has been passed by the Deputy Commissioner without any jurisdiction and authority of law that your Lordship will find at page number 124. Whereby he declared that, Lordship, the registered sale deed is legally unsustainable and invalid. And Lordship thereby cancel the registered sale deed. And in this regard, this Honorable Court on 10/6/2025 directed the Deputy Commissioner to file an affidavit under what provision of law he acquired an exercise to cancel the registered sale deed, Lordship. And in reply, Lordship, the same thing which has been, Lordship, stated in the impugn order that has been filed by the.
You are aggrieved by which order?
Your Lordship will find at page number 124.
124.
Yes, your Lordship.
What is your grievance here?
Grievance is that, Lordship, the sale deed has been registered with due procedure of law. And at that time, Lordship, the state of Assam has amended the Registration Act as Registration Amendment Act 2021, amended the section 21A of the Registration Act, whereby, Lordship, the legislature has, Lordship, some requirement which was earlier required for registration of sale deed, Lordship, like NOC and other permission from the authority, Lordship, that has been strike off from the, Lordship, provision. And thereby, Lordship, the necessary NOC from the Deputy Commissioner and from the other authority at that time, it was not required. Therefore, Lordship, the sale permission which has been applied by the petitioner, that has been, Lordship, closed down, and accordingly, Lordship, the petitioner has permitted to register the sale deed. Your Lordship will find the sale deed at page number 66.
You wanted to register a sale deed.
I have already registered.
Registered. Then,
Yes, your Lordship.
Then?
And it was registered on 16th of September 2022. And Lordship, after more than 2 years, 6 months, Lordship, the Deputy Commissioner has passed this order in the year 2024 on 27/8/2024 without issuing any notice to the petitioner. And
What is the effect of the order?
effect of the order is that your lordship will find at page number 125. Operative person, accordingly, based on the inquiry report and the legal provisions cited above, the execution and registration of sale deed number so and so dated 16/9/2020 is found to be legally unsustainable. The deed having been executed in contravention of the mandatory legal provision is declared invalid for registration and transfer of ownership. Consequently, any mutation carried out on the strength of the sale deed is rendered irregular and is liable to be cancelled at the discretion of the competent revenue authority. The parties concerned are advised to obtain the necessary NOC in order to carry out any mutation on the same date. Your lordship will find in this order, lordship, that it is, lordship, started from page number 124. May I read, lordship, entire impugn order, lordship? Everything is clear here, lordship. The deputy commissioner, which has been relied.
When was the amendment given effect to?
It was 15 February 2022.
15 February.
Yes, your lordship. 15 February 2022 until 6th of December 2022, lordship.
And your lease deed was registered on?
16/9/2022.
So this is during the currency of the
Yes,
amendment?
lordship.
Uh,
During that period. There was no illegality in the registration of sale
Illegality
deed.
or not, but it did not satisfy the requirements.
No, lordship, at that time, that amendment has been brought by the legislature and that was fulfilled in this lordship, when the registration was made, lordship.
So but they say that it has not been fulfilled.
Lordship, it was lordship, his consideration, which has been, lordship, considered by the deputy commissioner. It was, lordship, after 26th of December 2022, lordship, which was operated in the year 2024.
What is the stand of the respondents here?
The respondent number, your lordship will find at page number 131 of the affidavit filed by the respondent number 2. That the paragraph 4, the deponent begs to state that after reviewing the documents submitted by the petitioner along with the statutory provision governing the matter, it has been observed that the sale deed in question failed to comply with the essential legal requirement, section 32 of the Guwahati Municipal Development Authority Act 1985. Explicitly stipulates that no deed transferring land within the Guwahati metropolitan area may be registered without a no objection certificate from GMDA approving the transaction. In this case, the petitioner submitted NOC number so and so pertains to only to the construction of RCC building and does not cover the outright sale of the underlying land. The lack of a valid NOC for the land transfer rendered the registration of sale deed non-compliant and with the GMDA Act
Doesn't
1985.
satisfy.
Lordship,
The requirement was not satisfied.
lordship, unless and until, lordship, the deputy commissioner is empowered to, lordship, issue an NOC. Deputy commissioner is only the authority who will determine the value of the land and accordingly what amount that need to be paid to the lordship GMDA after enclosing the NOC from the deputy commissioner, it can be issued by the GMDA. Otherwise, GMDA has no authority to issue any NOC without the NOC of the deputy commissioner, lordship. Because at that time, NOC was not required, lordship.
Mr. Goswami, what do you say?
My lord, this is something fishy. As my lord, my learned friend has submitted, my lord, there was no hearing at all. In fact, my lord, in the year 2012, my lord, they applied, the petitioner, present petitioner number 2, applied for permission for construction of his building out of 3 kothas of land, my lord. Half of the 3 kothas, my lord, your lordship will find first affidavit, your lordship will.
There's only one affidavit.
I'm submitting, page 36.
16.
Yes, yes, my lord. Your lordship will, page 36, lordship will find.
36
Petitioner, yes, page 36 of the writ petition.
of the writ petition.
My, this is an affidavit, my lord, based on which the permission for construction of house of the petitioner number 2 was obtained, my lord.
Yes.
That I am Nilima Buisho, so paragraph 1, 2. I am the absolute owner, so possessor, so plot of land, presiding, so. That Sri Rana Kumar Buisho and Sri Rakesh Buisho are my sons. That my younger son Rakesh Buisho intends to construct a residential building over 1 kotha 10 lasa in the western part of my aforesaid 3 kothas of land. That I have no objection. So no objection certificate was given by his mother, my lord, way back in the 2012, my lord. So for the purpose of construction of his building, my lord, the entire area was 3 kotha, and the permission for construction of the house was obtained, my lord, for 2 sons were there, my lord. And when this was done, my lord, the daughter of petitioner number, first son, Rana Kumar Buisho, my lord, filed an objection. The petitioner himself has stated, my lord, at paragraph 8, my lord. Lordship will find paragraph 8, my lord. As he has stated, my lord, there is no. There is objection. Lordship will kindly see. The petitioner humbly submits it after almost paragraph 11, my lord. Sorry, page 11, my lord. Paragraph 8. They submit after almost 2 years. The petitioner petitioner number 2 came to know one, namely Suhansi Buisho, the grandchild of petitioner number 1, filed an online objection on the land record portal against so-and-so. Therefore, the petitioner number submitted an application for disposal of the removal, online objection submitted by so-and-so. Accordingly, additional deputy commissioner so-and-so, after hearing the submission of the petition, satisfied that it has been sold by the petitioner number 1 as per the absolute so-and-so and such. My lord, here is a case, my lord. The petitioner approached this honorable court without making party of the said person who filed the objection, my lord. That is their property, my lord. And my lord, the order passed by the deputy commissioner, who is also appealable under the regulation. Apart from that, my lord, this is a mandatory provision in the GMD Act 1985. Lordship, I will.
All right, we'll come back at 2 p.m.
Yes, welcome. Well, notice was served on the petitioner as well as the, my lord, complainant, that is page 109.
Now, what is challenged here is the order of the DC.
Yes, that I'll make my submission on this point. And before that, my lord, I would like to clarify some matters, my lord, some notes, my lord. Number 1, my lord, this is not tenable because this is a non-gender of priorities, my lord. Because it is not a case that without hearing, without any basis, that was done, my lord. That is incorrect. That I am saying, my lord. And my lord, order passed by the deputy commissioner, my lord, that is appellable order, my lord. As per the regulation, my lord, regulation 147, it's an appellable order, my lord, before the revenue board, my lord. So far factual position is concerned, my lord, certainly that revenue board will be the competent forum, my lord, to decide the issues, my lord. And my lord, the GMD Act says it's a mandatory requirement. Permission has to be obtained from the GMD authority, my lord. Apart from DC, my lord, before selling the property, my lord, that has to be done. And my lord, other things are there, my lord, which in fact, the present petitioner number 2 has done everything. I think, my lord, in after going through all these things, my lord, surreptitiously he has done, my lord. Even to deprive someone, my lord, this is a process initiated by. That is why my submission is something fishy is there, my lord. So it is not a case, my lord, that authority did not take into account other aspects of the matter. my lord.
His contention is that at the time
My lord, my lord, DC permission is not required.
when it was registered,
My lord.
that the DC had already given the NOC.
No, no one is.
Not
No.
required.
Not according to him, not required. Only on the ground that during 2012, they obtained instruction from the DC as well as the GMD authority for the purpose of construction of his my lord, building. That is why, based on that, as my understanding, my lord, he has proceeded, my lord.
But there was no NOC for sale.
My lord.
There was no NOC obtained for sale.
Yes, no, nothing.
Only for construction.
Yes, that was for only for construction. That is part of the land, not entire. And my lord, on feet.
What do you say about the alternate
Lordship,
remedy? We have an appellate forum.
Lordship, so far the submission made by the learned council, Lordship, I would like to reply, Lordship, in this, only my challenge before this honorable court is that whether there is any provision that has empowered the deputy commissioner to declare a registered sale deed is not legally sustainable, or has the deputy commissioner any power under the provision of the Registration Act that the deputy commissioner can cancel any sale deed? In this regards, Lordship, the honorable court in the case of Satyapal Anand, Lordship, honorable court has clearly says that, Lordship, once the registration has been made, if there is any illegality, then also deputy commissioner or district registrar has no authority to cancel or declare it invalid. Only the civil court has the
There is
authority.
a case where, my lord, mutation has been cancelled.
I don't think, Lordship, the
Mutation
understanding
has
of
been
the
cancelled
order of this honorable court
in
was
view of the
wrong.
fact that the registration was obtained, my lord, that is, my lord, without complying with the requirement of law, my lord.
And
Only cancellation is only, my lord, the mutation, my lord.
And the
That
second,
part, deputy commissioner
and the
has always
second my
got.
submission is before this honorable court is that when the deputy commissioner's power has been seized to issue any NOC, and there was no requirement that has been enacted by the legislature declaring that if a lordship deputy commissioner has no authority to issue an NOC, it can be registered. It can be exempted from issuing any NOC, lordship. That is the law. Your lordship may kindly registration act on your. Thereafter, I will come to the Satyapal Anand judgment, lordship.
कौन गया है पता करके बताओ हमको. Yes.
Your lordship may kindly come to section 21A state amendment. May I read, lordship?
Yes.
Section 21A, no registration of non-testamentary instruments without no objection certificate. Notwithstanding anything contained in any other provision of this act, no non-testamentary instruments.
State amendment, which state amendment you're reading?
Lordship, Assam State.
Section 21.
Section 21A.
21A. Huh? 21A.
Your lordship, may kindly take up this.
Not here. in 24. So we'll have to rise. I think one of your colleagues expired and I'm told is
That is.
remains have been brought to the court. We'll just go there and come back 15 minutes maybe. We'll sit after 15. I think.
My lord, I am appearing 31, my lord. Item number 31, my lord, for the respondent, my lord.
Who's for the petitioner?
My lord, my colleague for 30 is also not present, my lord. He's Sarma. Yes.
This is for appointment of arbitrator.
My lord.
Where according to you, it is beyond the scope of the agreement in view of the limits.
No, here not, that is not the issue.
Okay. All right, we keep it for next week.
My lord,
Since the petitioners are not there. Mr. G.
Kusami, my lord.
Kusami appears for NF Railway.
My lord.
However, counsel for the petitioner is not present. Accordingly, matter stands fast over.
My lord, can it be on 3rd February, my lord, if not in
On third.
Yes, my lord.
All right, 3rd of February. 3rd of February.
Fine. Deeply obliged.
Let's say. Oh, particularly.
May it pleases your lordship. Your lordship, in this matter, the petitioner number 1 is the vendor and the petitioner number 2 to 7 are the intending purchasers. Now, the petitioner number 1 intended to sell some plots of land out of her total land, that is 3 vigas 17 lesses. And accordingly, sale permission was applied for, which was issued by the office of the District Commissioner, Kamrup Metro, Assam. After that, they applied for permission, land sale permission before the GMDA, which was also issued in their favor. They also paid the 1% total value of the transaction before the GMDA. They did that. And after that, they also purchased the requisite stamp papers. Now, on the day of registration, when they went for registering their deeds in the NGDRS, that is National Generic, now it is a portal for registration of the sale deeds, then it was revealed that their NOCs have been cancelled. NOCs have been cancelled and they went to the office of, inquired in the office of the district commissioner, and they were asked to inquire before the co-district commissioner, wherein they could find that the permissions have been cancelled on the basis of a letter issued by the circle officer, Dispur Revenue Circle, to the effect that the land require re-verification. And so it should be cancelled. So on the basis of that, the permission was cancelled by the office of the CDC, in spite of the permission being granted by the office of the district commissioner. Now, Lordship, the specific submission before this court is that we have never been issued any notice. We have not been rendered any chance of hearing before cancelling the permission which have already been accorded in our favor. Secondly, that re-verification, they are saying that re-verification is required for those lands and that is why the permission should be cancelled. But whenever a permission is applied for, then and there only the lot mandal goes and visits the plot of land. He does the requisite verification, and on the basis of that verification also only the NOCs are issued. Now, we having been issued the NOCs being applied, that means the verification has already been done. Now, if re-verification is required, there should be some specific reason why re-verification is required. No such reason has been mentioned in the letter dated or as well as in their affidavit that has been filed before this honorable forum. My lord, further, as per the Assam Right to Public Services Act 2012, we must be given a speaking order and also given an opportunity to appear before the appellate forum. Nothing has been done. No speaking order as such has been done. We all only came to know about this when we went for the registration of the seal deed. So no speaking order passed, even though it is an order of rejection. So we have been kept in the dark. It has been done behind our back. And for what reason? The reasons are also not apparent either from the notice or from the affidavit that has been filed. In the affidavit that has been filed by the respondent, they have not commented on anything in all the paragraphs that we have alleged. Only with regard to paragraph number 13, they have commented at para 8, or that is page number 2 of their affidavit, that with regard to the statements made in paragraph 13 of the writ petition, the deponent begs to state that it is seen after field verification. So they have done the field verification, that the government DAG number 5372 is different from the DAG which is in possession. Therefore, it has been stayed for some days. So here they
Where
are
is that impugned order?
impugned on page number 68. It is not an order as such. It is the screenshot of that NGDRS portal, wherein it is shown that NOC was cancelled. 68. And at page number 69, the very next page, that is the letter by the circle officer addressed to the co-district commissioner, wherein in connection with the aforesaid subject, I do hereby inform your good self that from the below mentioned office, the following cases by so and so have been sent to the office of your good self, and owing to the permissions granted by the office of your good self, the applicants have obtained land sale permission NOC. However, the land involved in the aforesaid cases need re-verification, and as such, the aforesaid cases need to be cancelled. Now, my lord, may kindly come to page number 52.
In this particular document, what is the NOC?
The NOC is a start from page number 52, Annexure 3. This NOC is with regard to the plot of land pertaining to DAG number 5373. So we have never applied for land pertaining to 5372. That is altogether a different plot of land. We do not own that land. We are concerned with 5373. It is reflected at page number 52. Page number 52. The third table, 1, 2, 3, 4, fifth column, DAG number 5373. Similarly, on the next page, the second NOC, that is 5373. Third is also Annexure 5, next page, 5373. Next, 5373. In all these NOCs, it is only 5373 that we are concerned about. We have applied for 5373 and we have been issued with regard to 5373. Now, 5372, how it can be correlated? And that is not our land. That may be government land, maybe someone else's land. We are not at all concerned with that. And in their affidavit also, they write that the government DAG number 5372 is different from the DAG which is in possession. So they are also admitting. So either way, this affidavit substantiate our case. If its government land is covered by 5372, it is okay. 5372 is there. We are concerned with 5373.
Yes.
It is within the, it has been stayed for some time now. So I have to write it. This is within the affidavit lawsuit. It has been stayed for some days. Does it mean that?
Stayed for some days, but in the NGDRS, it is shown as cancelled. NOC was cancelled. At page 68, it was shown that NOC was cancelled. Now, if they have stayed also, it has been stayed for a long time now. We made a representation also there, but till date, no order has been passed. No action has been taken.
You want your instructions here? Then?
Oh, yes, Lordship, some certain time is required for taking instructions because it is stayed for some time.
They have already taken instruction, they have filed their affidavit, and my lord, may come to the order 9/12/2025 also. They have been asked to take instruction with regard to the re-verification also. The last para of that order, so and so the learned state council is directed to obtain specific instruction as to whether any re-verification as provided for in the communication dated 30/4/2025 was done and its outcome. If such re-verification has not been done, this court would pass appropriate order towards disposal of the writ petition. Already lot of dates have been taken and the affidavit has also been filed.
Give us a specific date by which you can complete your instructions so that we can dispose of the matter. Huh?
On 13th February. 13th February.
Next week.
13 February.
I have a prayer that the petitioner number 1 is a very old aged person, more than 82 years old. So if it can be accommodated next week.
They have it on 9th or something.
Lordship.
9th. Let it be on 9th.
Lordship.
Third council for parties. By earlier order dated 9/20/2025. This court permitted the state council to obtain specific instructions as to whether re-verification as provided in the communication dated 30/04/2025 was done and its outcome. If such rectification has not been done, then this court would pass appropriate orders towards disposal of the writ petition. Pursuant thereto, when the matter is listed today, Mr. N. Goswami, Learned State Council, renews his prayer in view of the specific averment made the affidavit filed on 8th of December 2025 by respondent number 6. In para 8 of the said affidavit, or you say the averment in para 8 of the affidavit reads as under para 8 extra, page 75. Mr. Goswami submits that since it was stated that the NOC earlier granted has been stayed for some time, he would like to complete his instructions as to the status of the re-verification or re-verification sought to be carried out by the department. Considering the fact that the NOC which was earlier granted to the petitioners stood cancelled on the ground of re-verification. And since no specific reasons were issued by the respondent authority, nor an opportunity of hearing before the cancellation was granted to the petitioners, this court is of the view that the prayer of Mr. Goswami can be allowed, requiring him to obtain the specific instructions in this regard. An attempt will be made to dispose of the writ petition on the next date fixed. list again on 9th of February.
Deeply obliged. Item number 50.
That's it. Ar Islam, my senior counsel, he could not come to the court because of ill health. So pray for giving some time in the next month. I've already talked with you.
Prayer is made on behalf of Mr. R. Islam, counsel, the petitioner. Accordingly, matter stands deferred. We listed on 12th.
12 February.
12 February. Yes.
Lord, in item number 18, I filed an interlocutory application praying for improvement of the candidates appointed against the unreserved
So
category.
I was thinking because right now we are not taking up these matters.
Yes, bench
So I
strength.
think it's no point to keep it parted. Let it be before the appropriate bench so that later if again we are required to take up, we'll see, but keep it parted may not be a proper.
Understand. Lord, I just have one prayer, which I had made on the last occasion, and your lordship had given us liberty to renew that prayer today. My lord, if you're, I'll just take a minute, my lord. If your lordship recollects, these are 6 terminations were carried out. My lord. Now, one particular termination during the course of the hearing, this complicated question of migration from the reserve category to the general category came up, my lord, which is why my friend has now filed for impleement of the regular candidates. But now, this naturally will take time, my lord, I can understand. No? Insofar as the other 5 are concerned, my lord, they have got nothing to do either with reserve category or age relaxation. Those are on separate grounds concerning manipulation in marks, experience criteria not met, my lord. I'm not insisting that the matter be taken as part heard, my lord. Nevertheless, if those 5 matters are segregated, my lord, because those 5 candidates would unnecessarily keep
My lord, I appear for Indian Oil in all these matters. My lords, I'm requesting that I have requested my learned friend also, Miss Singh, who is the briefing counsel in this matter, is not available today. So let this prayer be made before her. I'm just requesting that. Just a short accommodation on that ground.
You make these prayers before the appropriate bench. Because even to allow your prayer, the hearing is required so far as those matters are concerned.
Perhaps, these are separate matters otherwise, separate
But
posts.
if the councils agree, then we have no difficulty in passing these. If the councils agree that yes, it can be segregated. So what do you say, IOC council?
My lords, I am requesting my briefing counsel, Miss Tanishta Singh, let it be done before her. Let her, because she might have some objections to that. So I requested sir also that if he can defer this for hearing, that won't cause any prejudice. So let it be heard on the next time.
Then we'll keep it what you want. You give us your date when you want it.
In time in February month.
Yes, Lordship. 3rd February would be, if 3rd February is okay with the side.
Third, we have some difficulty. Can it be on 5th?
5th.
List again on 5th of February. That's agreed to by council to party. But since this bench is presently not dealing with service matters within bracket civil bench Roman 3. Accordingly, these matters are released from being treated as part of matter will have to be listed before the appropriate bench on the next date fixed.
Deeply
obliged. Great, my lords.
Lordship, this matter relates to refixation and
Yes,
downgrading of
please,
the pay of the response petitioner.
Lordship, one of the member of the bar is died today, my lord. So my senior went there, my lord. So he's unable to present today, my lord. So I'm praying this matter may be fixed some other day, my lord.
Actually, Lordship, they were directed to seek instruction on 1/12/25. Yes, Lordship. I had received that instruction. Can it be day after tomorrow, Lord?
Day after tomorrow, no, let it come up in
5th of February.
28th.
Can it be 5th of February? And that week I have some.
5th February. Fifth of February.
Simply